member of the board of directors and president of the Detroit Music Awards Foundation. He's been appointed as a mediator, arbitrator, an expert witness in many, many music-related cases. Once describing himself in an interview as a frustrated rock and roll artist, he said he was able to turn his love of music into the focus of work as an attorney. Now, if you'll join me in welcoming your professor for today, Howard Hertz, as he tells us a little bit about his time as an entertainment law lawyer, answer some questions, and we'll give him a round of applause.
Thank you. Hold on one second here. I just want to change the view. There we go. So I started the possibility, at least, of becoming a lawyer in the 6th grade when my teachers, 2 teachers, would pull me aside and say, "You're going to be a lawyer." And that was because I would argue with them regularly and typically convince them that I was right, whether I was or not. And I didn't know what being a lawyer meant back then. And I haven't totally figured it out after 46 years, but I have a pretty good idea now. And it was in the back of my mind that that's what I was going to do. I was going to be a lawyer, again, not knowing what that meant. So when I started undergrad at Wayne, I knew that for law school, it wasn't that important what your major was, as long as you were somewhat studious, got decent grades, and were able to test well. So I started off, I think it was economics for some reason. I don't know why I picked that. I guess I had always been interested in investing, and I thought somehow if I took economics, that was going to help me. And I think I did it for 1 semester, maybe 2, and found it boring and decided to look elsewhere. I don't even remember what my second major was, but then I ended up taking a couple psychology classes and really enjoyed the psychology classes and decided that's what I was going to do, is major in psychology. Then I took a field study in psychology from 2 of the professors there, and it was meeting with young delinquents or would-be delinquents who had been shifted from the juvenile justice system into this program where you acted like a big brother, big sister. The psychology students would take a diverted youngster once a week for 2 or 3 hours and do an activity with them where you could communicate, not going to a movie, but maybe going miniature golfing or for a hike or something where you had time to talk to them and try to explain why being in the straight and narrow was a better idea than ending up in jail or prison. And I really enjoyed the program. I liked my professors, and then they hired me for the next semester to be a supervisor in that same field study where I was just meeting with the students and helping them to work through the issues that they had with their young students or their young delinquents, so to speak. So then I started thinking maybe I wanted to become a child psychologist, because during high school and undergrad, I was selling children's shoes. That's what I did to make a living. And I liked working with kids, and I thought it might be interesting to be a child psychologist. So I started talking to the 2 professors about it, who I'd become friends with. One of them was a psychologist at the juvenile court, Wayne County Juvenile Court, and the other was a probation officer at juvenile court. And they both said, no, you're better off, from, in their opinion at least, going to law school, because it gave you a broader range of things you could end up doing. But at the same time, there was a juvenile defender office, public defender office in juvenile court that I could work at and kind of combine the psychology, child psychology aspects along with practicing law. So I decided that's what I was going to do. And I enrolled at Wayne Law School. And after my first year in law school, as many students starting with their second year, either do a clerkship or work in a clinic or do something extracurricular to learn more about practicing law, I went to the juvenile defender office and made an appointment with the executive director. And he said, he met with me, and what can I help you with? I said, well, I'm hoping to start working here. And I told him my story, which I just told you. I said, it's kind of fate that I should be at the juvenile defender office. And his response was, well, that sounds great, but we don't hire law students. We don't even hire people when they first graduate from law school. You actually have to be a member of the bar for us to hire you. And as I learned in 6th grade, never take no for an answer. So I said to him, well, could I correct one thing that you said? And he said, what's that? And I said, you never have hired a law student before. I'm your first. And I was able to convince him of that, was able to get a job there, starting off part-time, but it soon developed into a full-time job. And I actually was working under the court rule that allows you to practice law in a clinic under the supervision of another lawyer while you're in law school. So while I was still in law school, my second and third years, I ended up with a full caseload, taking my classes early in the morning or in the evenings, and handling even jury trials while I was still in law school. But right after I graduated law school, I stayed at the juvenile defender office for a couple of years, but my wife, who was a teacher, had moved from one school district to another. She was a special ed teacher, and she moved from Wayne County to Macomb County. And her first day at her new school, she met one of the other teachers, and they hit it off and became immediate best friends and lifelong friends. They're still friends. And that woman's husband was a singer-songwriter who had just been offered a music publishing contract. And he told his wife that he was having trouble understanding what the contract said, and that he was reading books about it and trying to learn, the lingo and figure out, what to do about the contract. And finally, one day he said to her, I give up, I'm just going to sign it. And she said, you can't just sign it. You told me yesterday you don't know what it says. He said, I know, but I'm never going to know what it says. I don't get it. So I'm just going to sign it. She said, no, you can't do that. What did the book or books that you were reading say? Excuse me one second. And he said, well, the only thing I got out of the books of any real use was it said to get an entertainment lawyer. And I don't even know a lawyer, let alone an entertainment lawyer. And his wife said to him, oh, my friend Wendy that I've been telling you about, her husband's a lawyer, let's call him. So I got a phone call wanting to know if I could help to review and negotiate this music publishing contract, which I knew nothing about. But I said I would meet with him. And we met, he showed me the contract. It was just a simple, theoretically 3-page, quote unquote, standard contract that I think one of the unions actually had put out at the time. And I read it. He said, do you understand it? And I said, yeah, I understand it. He said, okay, you're way ahead of me. And I said, yeah, but I don't know what the choices are. I don't know what the industry is. I don't know, what the standards are in the industry. And he brought out the book that he had tried reading, which was a big, thick book. At the time, it was the Bible in the music business, called This Business of Music. And he said, if you read chapters, whatever it was, 18 and 19, I think, on songwriting and music publishing, maybe you can figure it out. And I reviewed them, and I was able to figure it out, and said, well, here, there's a few things we could do. There's really only a few objections that I have to the agreement. One is if this publisher doesn't get you any placements within a certain period of time, we would want the copyrights and the songs to revert to you. And I don't remember what the other comments were. This is going back to 46 years ago. But after I helped him, I realized that this is what I really wanted to do, because sixth grade was when I learned about being a lawyer. But when I was 6 years old, that's when I really learned about music. The first time I heard Elvis sing Hound Dog on the radio, I was hooked. And I've always loved music. And I said, wait a minute, you mean you can combine music and practicing law? I never knew there was such a thing as entertainment law until then. And decided that's what I wanted to do, but it was going to be obviously a gradual process, because in Detroit, at least at the time, there wasn't that much activity, at least that I was aware of. Motown had already left town in 1972, about 4 years earlier. And yeah, there were rock bands around, but I didn't see that much going on in terms of them hiring lawyers. But as it turned out, the publisher who had offered this contract and who I negotiated it with over the phone, one night I was at my client's gig, and I got to go to a client's gig. I thought that was pretty cool. And this young guy comes up to me. When I say young, he was 18, I was about 26, and he said, hi, I'm the publisher, and introduced himself. His name is Joel Martin, if any of you might know who he is. I assume, Jeremy, you probably do. And he told me that he liked the way that I had handled it, and he had just started on the business side of the music business. He had a lawyer, but the lawyer was older, retiring, and he wanted to work with that lawyer still himself, but he wanted to start sending other people to me, and then eventually, when his lawyer retired, use me as his lawyer. So I started to get referrals from him even while I was still working at the public defender office. And then soon thereafter, in the early 1980s, when I started my own law firm, he referred people like the band The Romantics and George Clinton's executive producer first, which led to me representing George Clinton and the Parliament, Funkadelic, that whole group at one point. I went from just representing one local singer-songwriter to representing people that were national and international within a relatively short period of time. So I've been doing that for a long time. I started off doing music, although soon after I formed my law firm in 1979, I did start working with a famous author, Elmore Leonard, who I was doing his copyright work and reviewing his contracts. I wasn't negotiating the contracts because he had a big Hollywood agent at the time who was mainly in charge of getting the deals and negotiating the deals, but I was reviewing them all for him. And when problems would pop up, I would represent him and help get rid of the problem. I guess a fixer of some sort. And as an entertainment lawyer, so I now, while probably 60% of my time is in music, the other 40% is a combination of film, television, books, and other miscellaneous entertainment related models sometimes come to me to represent them, to do their agency agreements, those types of things. So as an entertainment lawyer, I learned one of the most important things that you can do in any business, not just law and not just entertainment law, is to network. I learned that from that very first deal that I did in 1976 with Joel Martin as the publisher. He then referred people to me because he thought that I was doing a good job and I was good at meeting with other people and bringing them into the realm of what Joel was doing and what I was doing, and networking and putting people together to do projects. And then after Joel referred, like I mentioned, the Romantics and George Clinton to me, and then he started using me as his lawyer. He opened a recording studio. He became not only a publisher, but a manager, and he started managing a couple young producers in town named the Bass Brothers. And they had the need to have a production company set up and a publishing company set up and have their contracts drafted so they could start signing to their companies artists. So they asked me to represent them, which I was willing to do after they and Joel did waivers of conflict of interest, because I would be representing both of them, although in different matters. And we started signing artists to their production company. So I would send out the contracts and usually get them back without a lawyer being involved. Surprisingly, no one was hiring lawyers, which was the case earlier and why I thought it would be difficult to build a practice. But then I would get back the contracts and they'd be dated, signed. That's what I cared about. And then I would take a manila folder, write the name of the artist on the folder, put their contracts in it, put it in a drawer in the credenza behind me. And for the most part, expect that I'd never hear from them again, because I'm sure you all know that it is very difficult to break in as a new artist into the music business. And then one time I got a contract back, it was in 1995, and it was dated, it was signed, and the name I thought was interesting. It was Marshall B. Mathers III, and never heard of him. Most people had never heard of him at that time. And I put it in a manila envelope, put his name on it, put it in the credenza behind me, figuring I'd never hear from him again. And that time I was wrong. So I did get to work with Eminem. I got to participate with Marshall's manager, Paul Rosenberg, in negotiating his deal with Interscope Records and with Dr. Dre. And then I did the music publishing contract with a company at the time. It was Famous Music Publishing, which then became, I think it's part of BMG now. And I found that I was, from that very first deal, now working with, what became during the decade from 2000 to 2010, the largest selling artist in the world. So that was pretty amazing, and obviously, it was interesting at all times. So what do I do as an entertainment lawyer? And I break that down into 4 major categories. There are a million things that I do, as you may have heard when Jeremy introduced me. I'm on about a half a dozen different boards and different organizations that I work with. But in terms of as a lawyer, the first thing is I draft and negotiate contracts, whether it's on behalf of the artist, or I also represent labels and production companies and publishing companies. So I'm drafting and negotiating contracts. The second thing that we do at my firm, and I also have a partner, a young partner, Joe Belanca, who works with me for about the last 10 years now. And he focuses more on the copyrights and trademarks for our clients, both filing them and protecting them. The third thing that I do is dispute resolution. So I get involved in either trying to resolve a dispute before it gets to litigation, which is always the best case scenario, because litigation is so expensive for people that it often isn't worthwhile unless the particular dispute is over a lot of money. But I get involved in both litigating, and then I often get appointed by judges, mainly in town here, but sometimes I do cases in California or in Nashville, where I'm acting either as a mediator, an arbitrator, or an expert witness. So over the years, I've been involved in cases that have involved Berry Gordy, the Four Tops, the Temptations, Anita Baker, and then a host of other people who you probably wouldn't recognize their names, but I do get involved in cases where there's either a dispute that I'm representing one side or the other, or I'm trying to mediate or arbitrate the case. I think one of the most important things, and it, not just applying to law, but aside from networking, which I've also already mentioned, is that when you're choosing your career, do the best you can to find something that you have a passion for. I know you've heard it before, but you know, from my viewpoint, I know it to be true, because practicing law is a stressful occupation, like most are if you're, you know, deep into it. And entertainment law, although there are a lot of fun times, it's still very stressful, because the clients, a lot of them have big egos, they have high expectations, they think everything should be done now. So there's a lot of stress, but if you're doing something that you really have a passion for doing, you learn to live with that stress and work hard at doing the best for your clients that you can do. I think that's kind of my introduction about what I do, how I got there, in terms of, you know, explaining some of the fun type things that I get to do as part of my job, though. I mean, it's a tough job, but someone's got to do it. I get to go annually. I go to the south of France, other than the last couple years because of COVID. I go to the south of France to go to the International Music Festival in Cannes. Everyone knows about the Cannes Film Festival. Not everyone knows there's a Cannes Music Festival. So I've gone to that, I think, 22 years now. I also go annually to LA or wherever it is. This year it's in Las Vegas. I'm not going because of COVID, but to the Grammys. I don't always go to the Grammy actual ceremony, but I go into town for Grammy week, for networking events, for meeting up with clients, for going to parties, that kind of thing. Do the same thing, go usually every other year or so to South by Southwest in Austin, Texas. So there are a lot of perks that come with being an entertainment lawyer that people laugh when I say it's work, but it is work to go to France and LA and Texas. And I've been to London several times on business as well. So it's always interesting. But now I'd like to, I guess, open up for questions. And I don't know if I don't think we have too much in the chat room, but I think Allison, you're going to start.
We have a few questions that have come in from folks who registered for our event today. And Howard, thank you so much for sharing so many personal details about your path to success and creative and always interesting career that you've had. I think one of the things, maybe we could start with a question about maybe some of your favorite Wayne State memories, and perhaps there was a concert or performance on campus. You know, you were here at Wayne during a very interesting time in Detroit. So, you know, could you share with us a little more about some of your favorite memories from your time at Wayne?
Yeah, so I was at Wayne, well, before that at Cass Tech, which is also, I don't know if there are any Cass Tech alum as part of this group today,
There you
but
go.
well,
I
there you
see
go. Which is a great school, and I have only the best memories of having attended there, and I think I've learned a lot at Cass. And I'm still close with a lot of the people from there, including we have like our own kind of a Facebook page, not Facebook, but on its own. I don't even know what you would call it.
Kind of like a platform, like
Yeah,
a social
platform, yeah, for
Yeah.
Cass Tech 67 grads.
Yeah.
And Wayne, I started off, my brother was at Wayne, although he was graduating right around the time I was starting, but he was a fraternity advocate and was Sigma Alpha Mu, and I joined Sammy's, like, you know, first day that I was on campus. I went to the fraternity house. I think I moved in around the second week, even before pledging, moved into the fraternity house. And it was pretty wild, I must say. You know, if you've seen the movie Animal House, I think they took our story, but I'm not sure. I can't say for sure. But I mean, we would have, you know, parties where we would have farm animals and straw in the house, in the fraternity house, and I mean, just, you know, one crazy thing after another. And we got in a little trouble on occasion, you know, for doing things you weren't supposed to be doing. And I was on one of the things that I've done since during my days at Wayne is world travel. I've always been a traveler. And I took off 6 months in my junior year to go to Europe, North Africa, and Israel on a 6-month motorcycle trip by myself. And while I was there, I got a letter. I would pick up letters at American Express. That's how you used to do it. There was no, you know, phones, or, well, there were phones. You could do a payphone, but how did you couldn't connect to anyone really. But you know, no email, all that. But I got a letter one time from one of my friends saying that the fraternity had broken up, that the police came to the door and gave us a choice of disbanding the fraternity or going to jail. And they chose disbanding the fraternity. So when I got back, I ended up living down on Willis, right by 3rd, in an apartment where I could look out. I was on the first floor, look out my window across the street on the building, and it said "Girls, Girls, Girls," the Willis Show Bar. And we would watch the ladies of the night and their boyfriends, let's say, walk in front of my window to the apartment building / motel that rented by the hour a few doors down. So that was an interesting time. And during that era, especially I think before I took my trip in 1970, I would go, there were concerts. I think it was WABX put on a concert series in Tarter Field, which is, I don't know what it's called now, across the freeway. And there were some great concerts there that I remember, and really had a good time. And then one of my favorite moments at Wayne was just a few years ago when the College of Fine, Performing and Communication Arts awarded me the Arts Advocacy Award. And I just was really thrilled that to receive such an award. Only one person a year gets it. And if you look at the list, if I recall, people like Mike Ilitch Sr. and I mean, some, pretty major players in town have received that award. And I was very proud, and I'm still proud to have received that award. So that's some of my memorable moments from Wayne State.
Absolutely. Thanks for sharing. I know I've heard from other alumni that, the Cass Corridor era was a very raucous and fun and interesting time, but especially true, right, in arts and music. And that is still part of, our campus heritage today, whether it's the University Art Collection or, some of the amazing archives we have. It really captures the spirit of that era in
Right.
Detroit. So.
Right. Hold on one second. I think I have something. I got hired, I don't know, about 6 months ago or a year ago to help work on a documentary that's being made about Dally in the Alley.
There you go.
So Dally in the Alley, the name of the movie is going to be Dally On. And
Amazing.
I think they're just about finished. So it should be coming out in some fashion fairly soon.
That's wonderful. And hopefully, the return of Dally in the Alley is one of the kind of signature events in Midtown, perhaps
Right.
even later this year. Yeah.
Yep. I hope so. Hopefully the numbers don't shoot up again.
Yeah, that's right. I think this question in the chat overlaps with one that came in earlier. There's a question about what classes, internships, or other experiences, probably in addition to all of your networking from law school, best prepared you for your practice. And do you think that, your time in Detroit or in other places, helped you increase that network and those opportunities?
Well, let's start with the first part of the question because they're really unrelated. So the first part, I just need to get a drink of water. I was eating some almonds earlier, and there appears to be a tiny, tiny bit stuck in my throat. So in terms of classes in law school, the best classes, if you're intending on going into entertainment law, would be those related to copyright, trademark. If there is an entertainment law class, I did teach one for a while at University of Michigan Law School and at Wayne State Law School. I don't know if they have one now. Those would be the best. And then any type of clinic where you can actually work with clients and get in court is fantastic, because it's just getting used to, getting up, preparing ahead of time, making your arguments, being able to on the spot respond to the other side. I mean, those are invaluable things. So I think it was a misdemeanor clinic that I also did in addition to being at the juvenile defender office during law school. But the juvenile defender, I mean, if you can get I know the prosecutor's office also used to allow law students, but not too many. So I don't know if that's permitted or if they do it anymore. But if you can get an opportunity like that, or there used to be at the law school, there was a landlord-tenant clinic where you represented people being evicted. There was a misdemeanor clinic. I think there was a senior citizen clinic that you could be part of. And anything you can do to get experience in court is priceless. In terms of what law school to go to, okay, so Wayne is a great law school. But if you really think you're going to be in entertainment law, a lot of people have asked me, well, should I go to one of those few law schools around the country that really specialize in entertainment law? For example, Southwestern in Los Angeles has an entertainment law program that is, very well respected. UCLA has quite a few courses. I don't think they have a program the same as Southwestern. And at one point, one of my sons was thinking of going to law school to go, because he was already in the entertainment business. He was living in New York. He had gone to NYU to their music business program there, which is a great program. Not as good as Jeremy's program, of course, at Wayne, but it is a good program. And then he was managing a famous jazz pianist, McCoy Tyner, who was one of the, if not the most famous jazz pianists, or one of them anyway, in the world. He managed him for 8 years as part of the Blue Note Jazz Club, and then wanted to go back to school, though, to when McCoy wasn't working anymore and has since died. And he was considering going to law school or going to get an MBA, which is what he ended up doing, actually, was an MBA. But I asked one of my mentors in LA, a lawyer, what he thought my son should do in terms of, what kind of law school to go to if that's what he was going to do, whether he should go to like Southwestern or what he should do. And his response was that he should go to whatever the best law school he can get into, that it was more important to have a good law education than to specialize necessarily in law school in entertainment law. And it's really hard to break into entertainment law. You get caught in a catch-22, because if you go to, for example, a major label or a publisher to go work for them, they will often say, well, we really want someone who has experience working at an entertainment law firm already before they come here, so we don't have to educate them so much. If you go to one of the entertainment law firms, they say, well, we really would like someone who's already had experience at a record label or music publishing company first. So, you get caught in between there. So it's not as important necessarily what law school you go to. It's more important that you get a great legal education, wherever that is, whether it's at Wayne, at Michigan, at UCLA. There are a lot of great universities around the country that have law schools. But then, how do you break in? And the tough part is getting a job in a law firm that does entertainment law. So if you can't do that, what I've recommended to a lot of people, and it has worked for some, is to go to a law firm that's looking for a lawyer in some other field that you think you could either like or tolerate at least. So let's say it's real estate, and they're looking for a real estate lawyer. They're willing to train someone, come in inexperienced, have maybe a real estate course at law school or whatever, but have some business background, which by the way, let me backtrack a minute. The other thing you should do in law school is take business courses, take corporations, take tax, take business planning, anything like that, because in entertainment law, it is a business that you're working with. And the more business background you can have and the more you can learn about business and taxes and corporations, the better off you are. So what I've told people is you can go to that law firm that's looking to hire a real estate lawyer, as long as real estate's something you think you could I don't know, maybe tolerate's too harsh a word, that you could make part of your career. But right at the interview, the first interview, tell whoever it is, I love real estate. I really want to be a real estate lawyer, but I also have an interest in entertainment law. And I'm hoping that if you give me the job as a real estate lawyer, which that's going to be my focus, but that you'll allow me to develop an entertainment law practice as well. And I'll just, be careful that it'll be paying clients, that any law firm wants to hear paying clients. They don't want to think that you're going to be spending a quarter of your time or whatever doing pro bono for some musicians. They want to hear paying clients. So if you do that, and I know of those that have done it, and that has either led to them building a practice in the firm that they started, or then getting a job once they have some experience in entertainment law, getting a job with a real entertainment law firm where they can practice it full time. So I think that answer. Oh, cities, what cities? Well, in terms of obviously New York, LA, and Nashville are the biggest cities for entertainment. New York and LA being the biggest for law firms, but then there's also San Francisco. There's Atlanta is becoming more and more of a center for music, especially hip hop. And then Detroit and Chicago are great music cities, but there's not, there aren't like entertainment law firms. There was one or two in Chicago. They've splintered a little bit, and some of them have moved to Nashville. So, but there are opportunities. It's just you got to dig deep to find them.
That's great, Howard. Thanks so much. I think one of the other questions we received really kind of goes along that line of the entrepreneurial spirit, right? And kind of the changing opportunities that are out there. This is from someone who's a emerging audiobook narrator. They were interested in your view of how to be prepared for the use of artificial intelligence in copying or cloning voices with or without permission against kind of some of those emerging technologies that are, complicated.
Well, it's a good question that we don't know the answer to yet, but there have been a couple cases in the past over the last 30 years or so that might give some hint as to whether, the copying of voices would be considered infringement. One was Ford Motor Company wanted to do a commercial. I'm pretty sure it was Ford, wanted to do a commercial using a song that Bette Midler was famous for. I forget which song it was right now. And they asked her to do the commercial, to hire her to do the commercial. And she turned them down. At the time, a lot of artists thought that was, selling out to make money doing commercials. That's changed for the most part. But she said no. And they ended up hiring one of her background singers to do the song and to, in effect, imitate that. And it was a sound-alike. And Bette sued and won the case, where they said that it was so similar that it would obviously appear to others that it was her singing it, and she had already turned it down. There was another case where Tom Waits, who has a very distinctive voice, sued, I think it was Frito-Lay potato chips or whatever, for a similar thing where they used a sound-alike to, or someone who imitated his voice for a commercial. He sued and he won. So I think if the similarity is substantial enough, that people would think that it either was that actual person's voice or they had given permission to use their voice, I think that there's a pretty decent chance that that you could win the case.
Thanks, Howard, so much. I think there's a quite a detailed question in the chat.
Someone wrote a book.
Well, there are a lot of different things happening with TikTok these days. Do you want to go ahead and take a quick look at that and
Yes.
then try to answer? That'd be great.
Well, I'm not quite sure of the last part of the question, but it seems to me, and I'm not that familiar with this issue, but I'm familiar with the general, issue of streaming and royalties and rights. It seems to me that could be ripe for a class action lawsuit if there isn't one filed already. Part of the problem, and this is true, with Spotify and other companies like that, is that the major labels end up becoming owners of the streaming service, so they get a cut of the action, which is reducing their not their ability, but their desire to sue or to take strong action, because they're getting the money on the other side, which isn't necessarily being shared with the artists. So there's a lot of litigation that's been started around those issues, whether Spotify has the proper license. I'm not involved in the case, but there is a case that was brought by my clients, Marshall Mathers publishing company, not his publishing company, but the Bass Brothers publishing company that publishes and administers the rights to the first 4 or 5 albums of Eminem. And they're suing Spotify now, saying that the contracts that they had didn't give Spotify permission to use the tracks without there being an actual agreement. So it's a wild west still when it comes to streaming royalties, what rates. There's constant lawsuits being filed against Spotify, Pandora, and the other streaming services. And the courts and the Copyright Tribunal are trying to resolve those issues. But part of the problem from my viewpoint is that I think that the publishers and songwriters aren't being compensated as much as they should be, as compared to the record labels and the recording artists. And each time these cases have been going to court over the last few years, the percentage that the publishers and songwriters getting has been increasing. So then there was a question about independent artists. How do you defend yourself? Well, I mean, that's, again, Eminem's not exactly an independent artist, but his publishing company is going after the Spotify's. And you have to commit to the PROs and sign away your creative rights. Well, first of all, you need to be a member of a PRO. There's no question of that. But I don't know that you necessarily, I think you can tell your PRO that you don't want them to license your works for streaming, if that's your desire. And I think they can opt out for you, even though you might be getting your other performing rights royalties through ASCAP, EMI, CSAC, et cetera. And I don't know if Jeremy might, even have an update on all that. But it's a constantly moving target.
I think constantly moving target is a great way to put that. So we have a few questions from the classroom. And so one of my students is going to ask you a question right now.
Okay.
Hi, my name is Pat Norton. I'm a music tech major, but I was wondering, like, with the technology is rapidly changing with how like music streams and even like the sample-based music. How frequently would like an independent artist have to update their contracts with their publishers with, like, for example, like TikTok is becoming a large sort of quasi streaming website, and I know like Michael Jackson had like some faults in his contract where it was like never updated for streaming, or like it took him a minute to do that. How rapidly does the law change for compensation for artists?
At a snail's pace.
Snail's pace?
I mean, there was a Music Modernization Act a few years ago that did address some of the streaming type issues. There's litigation that's constantly pending. There's proposed modifications to the Copyright Act constantly to try to keep up, but it's hard to keep up. But then you run into, sometimes it's to the artist's benefit that the contracts are older. So for example, I was involved in a lawsuit, I don't know, about 8 years ago, 10 years ago, maybe, involving again Eminem's publishing rights and recording rights. And what happened there was we sued in Detroit and in California against Apple and Universal Records. Apple we sued, saying that they didn't have the right to put Eminem songs up on iTunes. And the reason for that was that there was nothing in the contract between Eminem and Universal at the time when we negotiated that contract. First of all, it was a short form that, for whatever reason, never got expanded to a long form, to our benefit in a lot of ways. And secondly, there was no downloading of music at the time that we entered into the contract. So there was no mention of it. And we said that Universal, therefore, didn't have the right to give Apple the right to sell downloads. And Apple didn't want to have to deal with every publisher. There's hundreds of thousands of publishers. They wanted to just deal with the record labels. So we actually went to trial on the case. And after we put in our case, the Apple turned to Universal, who had to indemnify them, and said, settle the case now, because they didn't want bad precedent and they didn't want to have to deal with every publisher. Then on the flip side, we had a case in California against Universal directly, saying that for downloads, they weren't paying the proper royalty to 8 Mile Style, which is Eminem's publishing company. They weren't paying the correct royalties to 8 Mile Style because they were only paying what you would pay for the sale of a CD or or vinyl or a tape under the contract. They were not paying 50% of their what they were receiving in royalties, which is the way the contract read for licenses. Usually when it was a license at the time, it would mean that someone was doing a recording or using a recording maybe in a movie or something else where there was a license. Universal, for example, would be licensing an Eminem song to another source, and it would be a 50-50 split. And they said, oh no, our deal with Apple, that's not a license. That's just another method of distribution, just like selling, and they literally in their arguments said, just like when it used to be an 8-track or then a cassette or then a CD, and now it's downloads. And the jury agreed with Universal. They were convinced. We appealed to the federal appellate courts, Ninth Circuit, which is California, West Coast, who agreed with us and said, no, it's obviously a license. So it should be a 50-50 split. Universal appealed to the US Supreme Court, who denied cert, which means it went back to the decision of the Ninth Circuit, and we ended up winning the case. So all artists at the time that had old contracts that didn't include downloads could now rely on what most contracts had of a 50-50 split. And actually a class action was brought on that basis for those types of artists. So sometimes when it's not in your agreement, you're better off, is kind of my long version of answering your question. Then other times what happens is publishers will come to you. I remember with several of my clients, Sony, and I think it was BMG, coming to me and saying, we want to renegotiate the contract now because we want to make sure that downloads are included, and we're willing to pay an advance of X dollars to the artist in order to, include it.
I have like one more question that will probably take like 2 sentences. For an artist that's looking to sign a contract, is it more so what's not in the contract that you have to watch out for more than what is actually included in the contract?
It's
Like
both. It's both.
Okay.
So everything is negotiable. And for example, something that isn't always in a contract, especially if it's a contract that's drafted for a independent label by someone who isn't as familiar with the business as they should be, or is trying to help this independent label by excluding an audit clause. A lot of times I'll get a contract, I say, where's the audit clause? The artist has to be able to audit the records at some point without having to sue in order to get a proper accounting. So yes, it's important to make sure that everything is there. And what I do is I always, when I get a contract, I compare it to, a form that I have that includes all the clauses to make sure that there aren't any missing that I want to make sure are in the contract. Hi.
Hi, my name is Ryan. I just had a quick question about like late 60s, early 70s, basically. The times when you said you were getting into a little bit of trouble. What did you really get out of that experience as far as like building a community or building that counterculture? What experience did you get out of it? With the exception of the troublemaking and all that, what did you really get out of the situation?
What my undergrad experience you're talking about?
I'm talking about the whole scene, like growing up around here and all that music going on, like having concerts out on the field, Tartar Field.
Yeah.
What do you think that culture really got out of that experience?
Well, I think that that community is important, and that by relating to other people that are of the same mindset, I guess, that you can build relationships that can last a lifetime and that it can improve on your quality of life. That, you know, by sharing experiences, whether it's, you know, going to a concert or at my beginning of my undergrad being in a fraternity, it just, those shared experiences teach you a lot. And it's something that you take with you in whatever you do, whether it's building a family or building a career or just living life.
Would you say, as far as the connections that you built, would you say a lot of those came out of that time period?
Yeah, I mean, like what I've done or tried to do, and I think I've done a pretty good job, is every step of my life, starting when I was in elementary school, I've always, you know, tried to keep in touch with friends and keep in touch with people and be someone who helps to bring people together. So for example, I went to Schultz Elementary School in Detroit, which was, at the time, it went through 9th grade. Because I went to Cass Tech and they had 9th grade at Cass, I was only there through 8th grade. But we had a group of friends that were really close at the time. And I was one of the people that helped to get everyone every 10 years or so to have a reunion. Just so you're seeing those people, and they each have, you know, you're only seeing them maybe every 10 years, but they each have their own businesses and they each have their own relationships. And then you can kind of tap into that to build on your own business or your own relationship. And all of a sudden, you know, I'm doing business with someone who I went to elementary school with, or one of my fraternity brothers now is just who was a musician and moved out to California and was, you know, trying to be a rock star. He's now getting back into the business and trying to engage me in helping to represent him and his project at 70 years old.
And that smile back on your face.
What's that?
Like getting that smile back on your face.
Yeah, right. It does. Yeah. Ed Nahat is in the waiting room. I know Ed.
One more question from the classroom.
Okay.
Not much time, so you can make it as brief as you need to, but I was wondering, regarding like music business and entertainment law, like what's an appropriate amount of clauses or like the length of a contract? Like what are the most important ones that you keep coming across having to include in your contracts?
I'm sorry, I kind of missed that because, yeah, thank you.
Hold on, my mask. Can you hear me better?
Yeah.
Okay, I was wondering, regarding music business and entertainment law, what's an appropriate amount of clauses for a contract, and like, what are the most important clauses to include?
Well, there's no number. I mean, you know, every contract is different. For example, the contracts that I do for a production company / independent label range from 20 pages to 40 pages, depending how deep they want me to get. But if I'm doing a deal with a major label, their contracts are up to about 120 pages. And, you know, a lot of the reason is because whatever issues might come up later in a dispute, the more detail you have in the contract, and if the language follows the language in an earlier court decision that ruled on that very issue, then it makes it more likely that the record label is going to be successful in holding the artist to whatever portion of the contract that we're talking about. So, you know, that's how they get up to 120 pages, because they keep adding and adding and adding clauses. So there's no certain number or certain magic to it, but I just got one yesterday from a prospective client that I read it over and I responded. I told them I would just take a quick look at it, tell them what it would cost to negotiate it. And I looked at it and I said, the contract's not clear enough for me to even tell you what rights they're trying to take from you, but they're trying to take too many rights and not give you enough. So And it was a 4-page contract, which wasn't enough to cover the issues. Now, I'm going to have to excuse myself for 1 minute or less. I'll be right back.
Jeremy,
Well,
are there any other questions in the classroom?
I'm not sure. Are there any other questions? Doesn't seem so. So maybe when Howard comes back, if there's other questions from the chat or that were pre-given. I noticed there was one about believing their work has been used without permission and profited by others. That one might be an interesting wrap up.
Yeah, I thought so too, Jeremy. You and I are exactly on the same page. So we'll ask Howard for sure. That sounds great. I get the sense that there are probably some budding artists in your classroom who are trying to make their way into the industry. So want to definitely make sure we hit that question.
I completely agree. I was just putting up your image so that people, there wasn't just a random voice in the room.
Oh yeah, good. Okay.
Thank you for
Yeah,
being willing to share this
great.
talk with our classroom. I know that I've appreciated this. We're not ending necessarily right now, but I wanted to get out my thank you, and I hope that's the same from all my students here. They appreciate, and thank you to Howard for this. So I'll leave it with Allison to wrap up.
Sure. Howard, Jeremy suggested we cover one last, maybe really useful topic for the whole classroom.
Sure.
You know, what steps would someone take if they think their work has been used without permission and perhaps other people have either taken advantage or profited from that? You know, what would someone do kind of as a first step, first action?
Well, the first step would be to get an entertainment lawyer involved that knows about copyright infringement.
Yeah.
For example, if someone samples your work, the test is whether the new work is substantially similar to the original work and whether the first person had access to the original work. So, you know, the classic case is George Harrison was sued over the song My Sweet Lord by the publisher that owned the song He's So Fine. And if you listen to the two of them and you're a real musicologist, you may, you know, say, oh, these are substantially similar. Honestly, I hear some similarity. To me, substantial, similar, I don't know, but that's up to a jury to decide. And in this case, the judge did decide that they were substantially similar. And when George Harrison said he didn't have access to the song He's So Fine, you know, everyone laughed at him. Of course he did. Everyone knew the song He's So Fine at the time. He couldn't credibly say he wasn't familiar with it. So that's basically the test. The more similar it is, the less of the access that you have to show. Now, if it's a sample where it's actually a recording that's taken and sampled into the new recording, then in the Sixth Circuit where we are, the test is any amount that you take of an actual sample and put in your new song, even if you've altered it so it's indistinguishable, that is copyright infringement, to discourage people from stealing other people's music and instead actually licensing it. So, you know, when people come to me, and I've done, I don't know, a dozen different copyright infringement suits, the first thing we do is listen to see, you know, whether it's really obvious. And then if it isn't that obvious to me, then we hire a musicologist who is an expert at comparing the two works and determining whether there is a substantial similarity and what those similarities are, and then decide whether we're going to actually sue or we're going to, try and settle it without a lawsuit. Because if it's someone public, very often they would rather settle it without a lawsuit and not have that bad publicity.
As a follow-up comment, would you recommend too that probably documenting the whatever, sample or the copy or those kinds of things would also be a really great step?
You always have to, yes. But
Document
one of the most important things that we haven't talked about is you should always file a copyright with the U.S. Copyright Office for any of your work before you share it with anyone else. It's really important because there's benefits. You own the copyright by virtue of creating a work, as long as it's in some tangible medium. But in order to prove that you created it, one of your best proofs is having filed a copyright, because that then puts the burden on the other side. You don't have to prove you wrote it because you have a copyright. The other side now has to prove you didn't. And you can get financial benefits as well, such as attorney fees and what's called statutory damages, if you file the copyright prior to the other person having copied it and within 3 months of when you initially release the recording. But I always say, do it before you release anything.
Great. Go ahead, in the classroom.
Hi, so I'm an artist. I frequently make music using a sampler, but that sampler does mangle whatever you put into it, and you can actually perform the sampler expressively, either using effects or like pitch shifting, like playing it like a keyboard, for example. In those cases of where you mentioned that a sample, even if it is completely indistinguishable, can still be a copyright infringement. How would you prove that it's not, like, let's say I sampled myself, but someone's like, oh, you're using a sampler and I like made this recording that you sampled, but you can't prove that you actually took that because it's like so altered. Like,
Right.
Is that a potential, just the use of the sampler, is that a potential threat to having a lawsuit filed against you?
Yeah, it's potential. I mean, anyone with, and I don't remember now what the dollar amount is, $60 or whatever the filing fee is, can file a lawsuit. What you should try to do, and I don't know the technicalities of it because I'm not an engineer, sound engineer, but you should try to keep records of every step of the way when you're creating something, and be able to say, no, on such and such a date, here's the evidence that I created this sample, then I altered it, and this is the result. I've been involved in cases where there was sampling and the plaintiff tried to lie about what he had done and created something that was false later and said, well, that was his originally, right? And when it came down to it, the expert witness was able to show that it was created later, and that both the artist or producer, I think it was, and the lawyer had basically lied to the court, and they were sanctioned for about $500,000. So it does happen. You have to be on your toes. You got to keep track of everything. It's complicated.
Yeah, all creative practices are, right? Well, I think Jeremy's class is winding down and wrapping up. So want to echo some earlier thanks and appreciation to you, Howard, for lending your story and your expertise to our students here.
Pleasure. I enjoyed it, as I always do. And it's great to see Jeremy after having worked on projects together for
Great.
a number of years ago. How long have you been at Wayne?
Sorry, I don't mute for a second. I've been here since 2018.
Okay, not that long. 4 years.
Michigan before then.
Okay.
I've been here full time since 2018.
Oh, the thunder has started.
I can watch it roll in there.
I know. Thank you guys very much for all your great questions and the wonderful conversation. Thank you to everyone who joined us on Zoom for our hybrid conversation with Howard. Feel free to hop on and give us a wave before you depart. But we'll look forward to sharing more of this and more events to come from the College of Fine Performing and Communication Arts.